Good afternoon, everybody. Welcome to our webinar today on the 2024-2025 Supreme Court term, specifically focusing on labor and employment cases that impact employers. I'm Mike Warner, and I'm joined today by another one of my colleagues, Reva Ghadge. As many of you may know, we are both attorneys at Franczek who focus our practice on representing employers in labor and employment matters in both the private and public sector. So without further ado, I'd like to turn it over to Reva, who will start talking about the cases from this last term. But before I do that, I actually getting the logistical issues out of the way. For those attorneys, Illinois attorneys who are listening today, we do have CLE credit available. If you're interested in receiving credit for today's presentation, please reach out to us at info@franczek.com. info at franczek.com. Thank you, and I hope you enjoy our presentation today. If you have any questions during the course of the presentation, you can put them in the chat, and Reva or I will do our best to get to them.
So the U.S. Supreme Court issued a number of significant decisions this year impacting labor and employment law. The term, of course, began in October of 2024 and ended in June of 2025. The court addressed both procedural and substantive legal questions under a range of federal statutes, including Title VII, the Americans with Disabilities Act, and the Fair Labor Standards Act. We're going to go ahead and talk about, some of these cases today and give you our insights into how we think these cases might impact, labor and employment law moving forward. Mike, I'm not sure if you wanted to.
Yeah. So one interesting overarching comment to note is that unlike what we've been hearing about and reading about in high-profile constitutional cases, particularly cases challenging activities of the Trump administration or cases dealing with hot-button social issues like LGBTQ issues or abortion and other issues of the like. For the most part, both from decisions in this term and recent labor and employment decisions really have not broken down on ideological lines as far as the court's makeup. And in fact, as you'll hear more as we get into specifics, many of the decisions have been unanimous or close to unanimous.
This term, there were 5 main cases on the court's docket which addressed labor and employment issues. We're going to touch on each of these, and we'll also talk a little bit at the end about Trump v. Casa, even though that wasn't technically a labor and employment case. It does, of course, have some implications for employers. The first case we're going to talk about is Ames v. Ohio Department of Youth Services. In Ames, a heterosexual woman alleged that her employer, the Ohio Department of Youth Services, did not select her for a position she applied for, and then later demoted her based on her sexual orientation, that as a heterosexual woman. Now, Title VII of the Civil Rights Act, of course, prohibits employers from discriminating on the basis of race, color, religion, sex, or national origin. And the lower courts actually dismissed Ames's case because they found that plaintiffs who are a member of a majority group, right, such as those who are white or heterosexual, are required to meet a higher evidentiary burden than plaintiffs who are members of a minority group, which prior to this case had been the longstanding accepted rule. And when we say longstanding accepted rule, this was the longstanding rule within the Sixth Circuit where Ohio is. This was not actually the rule that was used in the Seventh Circuit, and this led to a circuit split among the appellate courts, which the court stepped in to decide. Now, the question that was actually before the court was whether a plaintiff who is a member of a majority group, right, must meet a more stringent burden to prove that they faced unlawful discrimination under Title VII. Justice Jackson delivered the opinion for a unanimous court in this case, holding that Title VII does not require a plaintiff who is a member of a majority group to meet a more stringent burden of proof. The court relied on McDonnell Douglas, which is a very traditional framework in determining discrimination cases, and they found that the Sixth Circuit required a more onerous additional step to the first part of the McDonnell Douglas burden shifting framework. Now, this case is kind of a very clear example of how the Supreme Court often rules on statutory construction cases, different on those that might have constitutional interpretations, which I know Mike is going to kind of touch on in a couple of minutes. And this opinion ultimately aligns with the strict text of Title VII, which states, again, no individual may be discriminated against on the basis of race, religion, sex, etc. Mike, my initial thought here is that we might see an increase in some cases from those who might previously have felt they could not bring a case because they were a member of a majority group. But I'll turn it over to you for your perspective before we jump into Justice Thomas's concurrence in this case.
So, Reva, as you mentioned, within the jurisdiction that I believe probably most people on the call are worried about, namely the Seventh Circuit, as you mentioned, the Seventh Circuit has not applied different standards of proof for quite a bit. So I'm not sure if this decision standing alone will impact the number of type of cases and allegations that our clients receive. However, it is no secret that the Trump administration and the has been very vocal in active in using efforts to use federal anti-discrimination law to pursue claims on behalf of parties who are what we've characterized as part of the traditional majority group, i.e. white individuals, heterosexual individuals who have not, who historically have not been characterized as part of a minority who has been subjected to historical discrimination. So I think that the Trump administration's efforts, including their attacks on diversity, equity, inclusion initiatives by both private and public sector employers, coupled with this decision, certainly make people more aware of, even if you are in a group that is traditionally been viewed as a quote unquote majority group, that you may have legal rights under an ability to sue for discrimination if in an appropriate case. And one of the things that the facts of this case and the decision emphasizes is how fact dependent discrimination cases are. An individual who may be in a majority group in the population as a whole, in many cases may be a minority group within the particular workplace. For instance, if the employee has a manager or management chain who is of a different race or gender or gender identity. And this court makes it clear that just because you can't place people in groups based upon societal the societal status of somebody being in a majority or minority. Another part of this decision, and specifically Justice Thomas's concurrence, is something that's probably more interesting to lawyers and labor and employment law practitioners, but it may have some practical implications for those of you in human resources or in-house attorneys who are attempting to address and mitigate and avoid discrimination claims. As those of you who've practiced in the area now for years know, the seminal case describing how an individual, the easiest way for an individual to prove unlawful discrimination is McDonnell Douglas, a case decided in the early 70s, in the relatively early days of Title VII, laid out how courts should evaluate claims of discrimination. And that case basically set up a framework where a plaintiff first has to prove and show a prima facie case, meaning that they are a member of a protected group, they've suffered an adverse action, they were treated differently from somebody outside of their protected group. Once they do that, they get their claim into court. During the litigation, if the employer then has an opportunity to articulate and describe the non-discriminatory legitimate business reason why the challenged action was taken, and then it is the plaintiff's burden to show that the reason that the employer is giving for the decision that's being challenged was not the actual or true reason for the decision. Those of you who've been in employment litigation, or even those of you who have consulted with employment attorneys in assessing how to address a particular employment situation or address a threatened claim are probably familiar with that general rubric and concepts. Justice Thomas is saying that rubric is invalid and shouldn't be used by the courts anymore in assessing claims, and particularly shouldn't be used in when courts are assessing whether a case should go to trial at the summary, as courts do at the summary judgment stage. Justice Thomas isn't the only judge or justice to critique the use of or overuse of McDonnell Douglas. There are many Seventh Circuit cases that have questioned the utility of McDonnell Douglas in some cases, but he goes a bit farther in basically, suggesting that if he was in the majority, he would forbid the use of McDonnell Douglas. It remains to be seen whether this has any impact on how lower courts address these claims going forward. As someone who is very familiar and has been practicing for 30 plus years under the McDonnell Douglas standard, I question whether if courts truly abandon that, what replaces it, and how that will impact the ability for employers and employer counsel to truly assess, when there is a situation that exposes a company to liability, because without that framework and rubric and way of thinking about evidence, it could become difficult to assess risk when you're facing a potential claim. The other thing that I think is interesting or ironic to note is as everyone knows, Justice Thomas is known as the most, one of the most, if not the most conservative member of the bench. Historically, the conservative wing of the Republican Party, as well as the court, have been known to be thought and have been thought of as being pro-business or pro-employer. This concurrence in Justice Thomas's view on McDonnell Douglas, if anything, is a very pro-plaintiff or pro-employee view. And if his view were to win out ultimately among the lower courts, it could make it easier for plaintiffs to, in employment cases, to get their cases to trial. Again, that remains to be seen how it's played out, how this plays out. This is not a majority view. it's a concurring opinion. It's not binding. However, it is out there, and lower courts who are already somewhat skeptical of McDonnell Douglas could take this as concurrence as an additional reason why McDonnell Douglas shouldn't be relied on or given undue weight going forward.
And Mike, just to kind of close us out, I mean, the court did have the opportunity to hear a case that might have allowed them to review the McDonnell Douglas test, but they did in fact deny cert in that case earlier this year. So whether they choose to address that moving forward, I think only time will tell. The next case we're going to talk about is Stanley v. the City of Sanford. And the plaintiff in this case, Karen Stanley, was employed as a firefighter for the city of Sanford, Florida from 1999 until her retirement in 2018 due to an alleged disability. Now, when Stanley was hired, Sanford's policy actually guaranteed full health insurance coverage until the age of 65 for employees who either completed at least 25 years of service or who retired earlier than that due to disability. This was obviously a very big benefit. However, in 2003, the city actually revised its policy, and under the new policy, employees who retired due to a disability only received 2 years of health insurance coverage after their disability-based retirement. Now, the underlying district court in this case dismissed Stanley's case and said that ultimately she was not a qualified individual under the Americans with Disabilities Act because she was no longer employed by the city of Sanford and she wasn't seeking a job with the city. The 11th Circuit upheld that dismissal for the exact same reason. They said she was no longer a qualified individual. The Supreme Court granted cert in this case to resolve a circuit split over whether retirees are considered qualified individuals under the ADA. Justice Gorsuch wrote the opinion in this case, and they affirmed the 11th Circuit's opinion. This was an 8-1 vote in favor of upholding the opinion. And this opinion is kind of fractured and a little bit more nuanced. Parts 1 and 2 were written by Justice Gorsuch and were the opinion with the majority. 6 of the 9 justices agreed that Title I of the ADA does not apply to retirees because they must hold or seek the job in question when the alleged discrimination occurs. Now, because the ADA requires an employee to be a qualified individual, somebody who doesn't hold that job or is not seeking that job doesn't meet that definition. Karen Stanley stated that she was unable to work in this case, and she effectively foreclosed herself from being a qualified individual under the Act. The court held a plaintiff must of course hold or seek that job when the discrimination occurs, although as you'll see, the court didn't kind of completely close the door on whether a retiree could potentially still bring a claim. Now, the language of this opinion as well tracks directly with the language of the ADA, which talks about somebody who is a qualified individual in present tense terms, right? So it really focuses on somebody who currently holds or seeks a job and focuses on whether somebody in that position can presently be provided an accommodation. And like I said, this is kind of a fractured opinion. So part 3 of the court's opinion was once again Justice Gorsuch, joined by Justices Alito, Sotomayor, and Kagan, who all agreed that there are 3 potential points in time when someone may still be able to sue for changes to a policy, such as changes to their retirement benefit. None of these 3 categories shown on the scene applied in Stanley's case because her claims didn't arise when the policy change went into effect, nor when her benefits ran out after retirement. And again, she kind of closed the door on herself by stating that she was no longer qualified to do her job and that she was unable to continue working. So they ultimately upheld the position. Mike, I'd be really curious to kind of hear your thoughts on this case, though.
So initially, for those of you who are close court watchers, this highlights the non-ideological nature of many of these employment decisions, particularly when they're dealing with issues of statutory interpretation. If you look at the screen here and who joined this concurrence, you're not going to find Justice Alito, Sotomayor, and Kagan agreeing on much, but obviously they all joined this part of the decision in this case. The other thing from a practical standpoint that can't be overstated is this decision does not mean, as Reva has pointed out, that retirement plan provisions or pension plan provisions are immune from potential liability under the ADA in all cases. If you parse through the opinion, what this case comes down to is really a question of timing on the, as it impacted this particular plaintiff in this particular lawsuit. Because the person who brought the suit had already retired and was not able to return to work or seeking to return to work, that individual did not have standing to sue under the ADA. As pointed out in the concurring decision, what was not decided and still remains a possibility is whether a different plaintiff who is in a different status of their career or who brought the lawsuit at a different time period could pursue a attack on the change in the retirement policy under the same theory as this plaintiff and be allowed to proceed. So that remains an issue that needs to be fleshed out by the lower courts. But the takeaway here is employers still need to be wary of retirement plan or pension plan provisions that may discriminate against the individuals with disabilities.
Yeah. The next case we're going to talk about is EMD Sales, Inc. versus Carrera. And the dispute in this case was between EMD, which was a food product distributor, and 3 of its sales agents who sued EMD for violating the Fair Labor Standards Act, or commonly known as the FLSA, and the underlying claim was ultimately for overtime wages. I think, we see a lot of these cases in the labor litigation world, especially. Now, EMD claimed that the plaintiffs in this case were not entitled to overtime pay because they fell under an exemption to the Act. The trial court in this case actually ruled against EMD, and it held that the company had not met a clear and convincing standard as their burden of proof. Now, the clear and convincing standard requires an employer to show that it is highly and substantially more likely true than not true that the FLSA exemption applies. The Fourth Circuit affirmed that decision, and notably, all other circuits in the country besides the Fourth Circuit apply the preponderance of the evidence standard to FLSA cases. Now, the preponderance standard is a lower burden for employers. It really just means an employer needs to show that it is more likely than not, right? So greater than 50% likely that an FLSA exemption applies. Most civil cases tend to use the preponderance of the evidence standard. And for context, on the other side of the legal burden spectrum is, the criminal case standard, which is beyond a reasonable doubt. Clear and convincing evidence as a standard is supposed to fall somewhere between those two benchmarks. And again, preponderance is the standard typically seen in for FLSA cases. EMD applied to the Supreme Court to have them rule and weigh in on the appropriate burden of proof for employer classifications under the FLSA. This was a unanimous decision, and the court held that the preponderance of the evidence standard is the standard for when an employer seeks to show an employee is exempt under the Fair Labor Standards Act. For those of us in the Seventh Circuit, this kind of allows us to continue relying on this standard. It does not change the standard to a higher burden of proof and is ultimately going to be employer friendly. And it helps bolster our arguments that an employee has been properly classified by an employer. Mike, what are your thoughts on the impact or trends that we might see following the EMD sales decision?
So this is another decision, like many of the employment decisions that are, I think, really pretty nerdy and is of interest largely to lawyers who actually litigate wage and hour claims. And, to be candid, I'm not sure what ultimate impact this will have on, employer operations, other than in those jurisdictions that did apply the higher standard of proof, it does potentially make it marginally easier for employers to defend wage and hour cases where an employer is contending that the employees at issue are exempt from the FLSA. One thing to note under the FLSA generally is that in order to prove an exemption, it is the employer's burden to prove that, even under the preponderance of evidence standard. Again, that is, does reverse the burden from what is typical in civil litigation. For example, as I was alluding to, and as I mentioned under Title VII, in a Title VII case, throughout the case, it is always the plaintiff's burden to prove that they were subjected to discrimination. In a wage and hour case, if an employer is seeking an exemption, that is an affirmative defense, and ultimately it is the employer's burden to prove, yes, the employer is entitled to an exemption. That's why in wage and hour cases, it's important to have good job descriptions, accurate records, and documentation of the basis for an exemption in order to maximize the ability to meet that burden of proof and defend those types of claims.
I would echo that and just add, and Mike, please correct me if I'm wrong. As employers, you have the best knowledge of your employees. You are the most aware of what their duties are, and that ultimately leads to your classification of employees. And so to the extent you're able to document that clearly, that really just allows for you to have better defenses should that ever get called into question. The next case we're going to talk about is Weizsäck v. Halliburton Energy Services. We're not going to spend a lot of time on this case because it's pretty technical and practically speaking could end up meaning not a lot. In this case, the plaintiff sued his former employer, Halliburton, for age discrimination in federal court. There was a contractual obligation to arbitrate in this case, and so the plaintiff ended up voluntarily dismissing his case without prejudice. After an arbitrator ruled against him, he used a strategy that, you might have seen before, where he went back to the court and said, I think the arbitrator's ruling is wrong, and I'd like you to review it and see if he violated kind of any of the standards that might apply. Now, normally when we see an arbitrator's decision be brought to a court, we would see a new complaint filed. But the plaintiff in this case actually filed a motion under his original complaint that had been voluntarily dismissed, and he basically just asked the court to reopen that case and to vacate the arbitration award. The district court granted the motion to reopen the case and to start the proceedings under the original complaint. The 10th Circuit disagreed with this decision and said that a voluntary dismissal the way that it happened in this case, is not a final proceeding under the Federal Rule of Civil Procedure 60B. And 60B, again, is kind of technical, but it allows relief from a final judgment, order, or proceeding when done on a specific set of grounds that are listed in the statute. Arbitration awards have sometimes their own requirements for when they can be appealed to a district court, but they kind of mirror what's already in 60B. Now, the Supreme Court was asked to weigh in on whether the plaintiff's dismissal was a final action that could allow a reopening of a case under this rule of civil procedure. And the court was once again unanimous in this decision, and they held that a voluntarily dismissed case is a final proceeding under the rule, and so the plaintiff could reopen and ask the court to vacate the arbitration award. Now, what this ultimately means is that there's an expansion of the types of cases that plaintiffs may be able to reopen under the federal rule 60B. And it may really lead to plaintiffs filing initial complaints in a court of law, knowing that they can potentially voluntarily dismiss them, go to arbitration, and then just reopen their complaints filed. I'm not sure that this will take away any of our arguments as defense attorneys or any employer arguments that they might be able to make that an arbitrator's award should stand. And I don't necessarily think this is going to change the standard of review that a court has over an arbitration decision, for example. But Mike, I'd be interested in your thoughts.
Yeah, this is another case that I think is primarily of interest to practicing lawyers who like to nerd out on esoteric rule issues under the federal rules of civil procedure. I guess the only practical impact I could see here is that in cases where there's a employment claim filed and the employer defends on the lawsuit on the grounds that the case needs to be deferred to arbitration, it may result in employees and their attorneys attempting to, rather than if they want to challenge an arbitration decision after the fact, doing so in the original lawsuit that they filed, as opposed to filing a separate lawsuit attempting to vacate the arbitration award. I guess the advantage for employees and disadvantage for employers would be that they could avoid a second filing fee of filing a new action. But again, I think that that is nothing that is going to really substantially impact employers generally. As Reva alluded to, there's nothing in the decision would suggest that the very stringent standards that courts apply for reviewing and overturning an arbitration award remain in place, and this decision has no impact on what the standard review that courts apply when somebody is seeking to overturn an arbitration award.
So our next case, Williams v. Reed, is another Supreme Court case that addresses kind of a procedural issue. The plaintiffs in this case were 26 unemployed individuals who filed suit in Alabama State Court and argued that delays by the Alabama Secretary of Labor in processing their unemployment benefits violated their due process and statutory rights under Section 1983. They sought an order to compel the Alabama Department of Labor to promptly make decisions regarding their benefits claims. The Secretary of Labor, the Alabama Secretary of Labor, moved to dismiss on several grounds, and the trial court granted the Secretary's motion without providing any rationale. The Alabama Supreme Court affirmed that ruling and held that Section 1983 does not preempt Alabama's administrative exhaustion requirements. So these plaintiffs were required to fully exhaust their rights and remedies in the Department of Labor before they appealed to the courts. Now, the plaintiffs were caught in what the Supreme Court would eventually call a catch-22. They couldn't challenge the delay by the Alabama Department of Labor without first completing the administrative process that they claimed was being unlawfully delayed. The Supreme Court was therefore asked to decide whether a state's administrative exhaustion requirement can bar a 1983 claim in a state court. In a much closer decision, this one was 5-4, the court held that state courts may not dismiss a 1983 claim on failures to exhaust grounds. When doing so, kind of effectively immunizes a state official from liability under a federal law. In other words, a state agency's delay in adjudicating a request cannot be grounds for dismissal under 1983 in a state court. Now, the court stressed that their ruling in this case is really narrow and does not go beyond the court's existing precedents. The narrowness of this ruling doesn't take away other administrative exhaustion requirements, right? Such as requirements to file before the EEOC or through a grievance procedure if necessary. And it also doesn't change the fact that 1983 ultimately has a remedy in federal court. So a plaintiff kind of always has the right to bring this claim in federal court. They don't have to go to a state court. Mike, I know this case is kind of technical, but do you have any comments on whether you think this case might have an impact on state agencies and whether they attempt to kind of adjudicate claims faster?
To be candid, again, I really don't think it'll have much of an impact. This is, again, a very esoteric issue. It does emphasize the theoretical remedy that a individual has, under federal law and the ability to sue either in state or federal court if they are claiming an administrative process is being so delayed to be completely ineffective. But as you note, it's important to stress that it doesn't really have any impact on the sort of issues that we typically deal with and our clients typically deal with. As you alluded to, it doesn't change the ability of employers to rely on other exhaustion requirements, such as the need to file an EEOC charge or charge with a state civil rights agency before proceeding with a discrimination claim. And it certainly doesn't change the very well settled principle that if an employee is raising a claim that impacts or implicates terms of a collective bargaining agreement, and they're claiming that a collective bargaining agreement was violated, they need to go through the grievance process of the collective bargaining agreement and arbitration process, and they have to exhaust their administrative remedies in that form. They can't go into court.
The last case we're going to talk about is Trump v. Casa. Now, this case wasn't specifically a labor and employment case, but it is a rather important ruling on the use of nationwide injunctions to bar enforcement actions across the country through lower federal courts. And really to use a single or maybe a couple of plaintiffs to enjoin a business, or that we've seen lately, the federal government, right, from taking action nationwide. The justice's opinion ruled that equitable remedies, like injunctions, are limited only to the parties in a litigation, right? They also noted that nationwide injunctions likely exceed the authority granted to a federal district court. But the court did make a separate point to say that class actions are a tool that can still be used to obtain broader injunctive relief for similarly situated individuals, kind of notwithstanding the rest of their opinion. Ultimately, the three cases under CASA that were ruled on altogether were not class actions, and so their nationwide injunctions were stayed. From my perspective, this ruling has some pros and some cons, right? For example, a nationwide injunction may no longer be a tool to stop the withholding of federal funding, which is something we've seen them try to be used for lately. But simultaneously, employees who are seeking to enjoin an employer from some alleged bad practice can no longer rely on a single claim to gain a nationwide injunction, particularly for, multi-state or national corporations, unless, of course, they're seeking a class action. Mike, I would love to hear your thoughts, though, on the implications of Trump v. CASA.
Yeah, this case has gotten a lot of publicity. The underlying issue deals with Trump's executive order attempting to end birthright citizenship. The court did not rule on the actual merits of Trump's executive order, but just addressed this nationwide injunction issue and held that the district courts could not, on a nationwide basis, enjoin the enforcement of the executive order based upon a lawsuit filed just by an individual plaintiff or group of individual plaintiffs, and that any injunction entered would be limited to the parties in the case. What's important more broadly is that the reasoning of this case is not just limited to lawsuits where parties are seeking to enjoin the executive branch of the federal government from taking certain action, and that's the use that's gotten really the most attention here both in this case and in other cases in recent years. It really applies to any case where a party is seeking a temporary injunction or preliminary injunction at the outset of a case to enjoin broad conduct that may impact more than the parties to more than the plaintiffs to the litigation. So it could have an impact and provide a defense to employers who are faced with a lawsuit where a individual or group of individuals seek to enjoin an employer practice or policy broadly. And the court made it clear that a court can't do that now if without having all impacted parties in the lawsuit. So in this case, if a company or if a party does want to seek a broad injunction, and it could be broader than the parties to the lawsuit, but maybe not nationwide, and I think this rule still would come into play. A litigant really, in order to obtain a broad injunction, would have to show that the case can be maintained as a class action, and the litigant is qualified under the class action rules to represent both themselves and other similarly situated parties who could form part of that class. So I think it does make it less likely that both federal government entities, state government entities, municipalities, and even private employers are less likely to face these sort of broad injunctions.
So that is the last case specifically we wanted to talk about today, but we will open it up for questions if anyone has questions.
And right now, and I apologize, I do see that the only question or comment is somebody noted there was an echo on the sound. Hopefully that has been resolved during the course of the presentation. If it hasn't, what we will do is see if this is being recorded, and if there's a way we can adjust the sound and send out a recording that cures any echo problem. We're certainly happy to do that. And I apologize for any technical glitches that occurred during today's presentation if they impeded your ability to enjoy the webinar and to hear Reva and I. So I'm not seeing any questions. So if we have no questions, we can end the webinar. And I hope everyone has a good afternoon. And if anyone has follow-up questions that they don't want to ask today, you can reach out to Reva and I directly, and we'd be happy to answer your questions.